Well, thank you. I just want to reiterate, as a former staff attorney and as a former volunteer attorney with Remain, that what you're doing today is wonderful, and I really applaud you all for taking the time to be here and for taking on a pro bono case. There was a tremendous outpouring a couple of weeks ago of attorneys showing up at the airport to protect arriving refugees and foreign nationals. And everyone wanted something to do, right? Everyone was ready to sue. And a couple of people did. We had a couple of causes of action. But if you're looking for something to do, there's no better thing you can do than take a case from Remain and then take another one. And eventually, we will be able to sue. Right? There's so much coming out every day. But these are the cases, like Ashley said, where you are really changing a life, and in turn, your life will be changed as well. So thank you for being here today. We're going to talk today, and this is very Colorado specific, so I hope all of you are licensed in Colorado. If not, we'll refer you to a case in another state. So step one, we're going to talk about the predicate order. In Colorado, from which venues can you obtain the predicate order? And specifically today, we're going to talk about the two most common venues that your Remain case will fall under. But I want you to be aware that this order can be issued in dependency and neglect proceedings. That's when a child is in foster care, and our county departments of human services have initiated removal of the child from a home, the child's in foster care, the child's in front of a judge to check in to make sure that that foster care placement is appropriate. Parental rights are trying to be restored or possibly will be terminated at some point. I want to mention briefly dependency and neglect because I have had cases where the child was my client at Remain, and we initiated a guardianship proceeding, but that guardianship fell through and the child was referred into dependency and neglect proceedings. So just keep that in the back of your mind. Another possible venue are delinquency proceedings, and Remain attorneys and ex-attorneys are experts in delinquency proceedings. So if your child picks up a juvenile charge, you may want to check back in with Ashley or the other children's program attorneys to see if perhaps that order can come out of the delinquency proceeding. Adoption proceedings is something that I'm going to mention at the very end because it might be a possibility if all other possibilities have been extinguished. But today we're going to focus on the probate courts in Colorado. Those are the district courts. This is where they hear guardianship petitions, and we're going to focus on family court. And like Ashley said, in Colorado, we have a fancy word for custody. It's called the allocation of parental responsibilities, and we talk about parenting time and decision-making responsibilities within that allocation of parental responsibilities. I do want to mention that, and hopefully Remain will screen for you, but there is a burden, right? There is a burden in your state court proceeding. You have to establish that you're eligible to go into the state court proceeding, as well as the child is eligible for the special immigrant juvenile status findings. So I'm going to talk a little bit about that evidentiary standard and the procedure that you need in order to get into the state court. So for each venue today, and again, we're talking about guardianship and then APR, I'm going to talk about the procedure, some obstacles, and then the SIJS order. And as a reminder, I think that Christine said this too. Each of these could be a day-long CLE, right? I'm just giving you a broad strokes of what you need to do. And I really encourage you to dive in, to read the Colorado Revised Statutes, to familiarize yourself with local county policies and court procedures, depending on where you're filing each of these possible petitions. Okay, so how do we decide between a guardianship or an allocation of parental responsibilities? And the first question that I encourage you to ask is, who is seeking custody of the child? Is it a parent or is it a non-parent? Typically, a parent does not need guardianship over their child. However, a parent may want full custody over their child because father, husband, ex-husband has been abusive or neglectful, or wife. I'm just being stereotypical. But a parent, their proper venue will be in a custody proceeding and a petition for allocation of parental responsibilities. A non-parent can basically choose their forum. Do they want to do a guardianship? Is that more appropriate? Or do they want to do an allocation of parental responsibilities? And let me skip down to my last bullet point here. When we talk about custody in Colorado, my partner or my boss talks about a spectrum of what it means to have custody of a child. You can have a power of attorney, which is just a handwritten instrument that's been notarized that delegates decision making or custody of a child to someone else. Like, for example, if I'm sick, I want Ashley to take my son, I could do a power of attorney, and that would give her the ability to enroll my son in school, take him to doctor's appointments, etc. A power of attorney doesn't work in the context of special immigrant juvenile status because there is no state court jurisdiction. It's just an agreement between Ashley and I. Guardianship is one step higher. My boss likes to say guardianships are easy to get and they're easy to undo, because if a guardianship is granted and a parent then steps in and says, no, I want to take my child back, the guardianship is dissolved. Unless, and we're all attorneys, so there's the law and then there's always these but see. So we'll talk in a minute about in a case where that wouldn't be as easy to do. Allocation of parental responsibilities is a little bit stronger than a guardianship because you're actually laying out when does this person have time with the child. And an APR, for those of us who have been divorced, all of you know that an APR can come out of a divorce proceeding, right? My ex-husband has the kids on these days. I have the kids on these days, and then we split these holidays. An APR in the context, and not in a divorce context, is the same thing. But you're delineating who has powers when. In neither of these cases are you terminating parental rights. I just want to make that clear. But the APR is stronger than a guardianship. And then on the final end of the spectrum is adoption, which is a termination of parental rights and is sort of the most severe type of custody that you can have because you're terminating the legal relationship with the biological parents. If you have a non-parent who is seeking custody of a child, you also have the possibility of venue shopping. In some cases, we have some judges in some counties who don't understand SIJS and may not want to grant the order that we're requesting at part and parcel of the guardianship or APR. And so Ashley or Alex or whoever refers you a case will make sure that you understand, look, in Arapahoe County, the judge hearing matters in probate is not going to issue the SIJS order. So even though it's a non-parent, the proper venue is to do an allocation of parental responsibilities. And this saves a lot of time and energy and headache for everyone because some judges will grant you the guardianship, but they won't sign the order for immigration purposes. Another thing to think about when choosing guardianship or APR, particularly if you're a non-parent, is timeliness. How fast do you need to get into court? A guardianship, typically you can get into court faster because you just have one hearing. Whereas an allocation of parental responsibilities, you're going to have an initial status conference. And then you're going to have the judge saying, you need to do X, Y, and Z. I don't have A, B, and C. And then you might have a second hearing. And then you have to meet with a court facilitator. And then you might have your final hearing. So something to think about, too, is timing. Another piece to also think about that's not on here is the child's age. Okay, if you have, which just under my breath I will say is typical of RMIAN, a 17-and-a-half-year-old, right, who needs to get into state court. Which court is best for that 17-and-a-half-year-old? Because if you go into a guardianship proceeding with a 17-and-a-half-year-old, that judge might say, why does this kid need a guardianship for 2 weeks? He's going to be 18 in 2 weeks. So perhaps an APR is a better forum for that child because an allocation of parental responsibilities can be extended to 19 if you are requesting child support from the opposing party and in some other circumstances. So that's another factor to consider when you're deciding between guardianship and APR. One thing I will say that my boss and I were just talking about is that there are limited possibilities where a parent could do a joint guardianship. Typically, if a parent files for guardianship, that judge is going to kick you out and say, you don't need guardianship of your own child, that's your kid. However, I mention this because we're in a context now that is increased enforcement by Immigration and Customs Enforcement. And so some parents may want to enter into a guardianship and say, you know, in the event that I'm deported, I want Ashley to take my kids. And there is a provision that in our probate code that doesn't quite fit this scenario, but it allows for a parent who within the next 2 years will die or otherwise become incapacitated to allow for a joint guardianship with another adult. So I put that out there too for your information. Something to think about with both guardianships and APR is that we do have a statute, a federal statute to which Colorado is a party. It's the UCCJEA, the Universal Child Custody and Jurisdiction Enforcement Act. And the UCCJEA states that a custody can be determined for a child who is living in their home state. So you acquire home state status when you've been here for 6 months. So in some of these cases from Remain, the kids may have just entered. And in those cases, you need to look and see, okay, the child's been here for 4 months, but do we have a basis for an emergency guardianship? And we'll talk about more about that in a second. Or do we have a basis for an emergency allocation of parental responsibilities? And how do we get the court to take jurisdiction now instead of waiting for 2 more months? Okay, so this is really hard to see. I can't even read it, but I'm blind. We're going to talk a little bit about the procedure of guardianship. And I've laid out the statute for you here. It's under Title 15 is our probate code. You need to take a look at it if you're going to file a guardianship. Who may petition for guardianship? A person that is interested in the welfare of the minor, or a child, if the child's over 12, can petition and nominate a minor. So you have to think with Ashley and Alex and the folks at Remain, who do I want to be representing? Do I want to be representing mom, or I'm not mom in this case, so I want to be representing aunt, or do I want to represent the child? A guardianship can be made if the court finds it's in the child's best interest, and then we have all these other pieces that you have to show. The parents' consent, parental rights have been terminated, parents are unable or unwilling to exercise their parental rights, or a previous guardian that was appointed for the child has died. Typically in these cases, you may be able to acquire the parent's consent. Okay, if or at least one parent's consent, right? A child is fleeing abusive dad, fleeing the gangs in Guatemala, arrives here, is living with aunt. You may be able to get mom's consent, but possibly not abusive dad's consent, okay? And in those cases, get mom's consent, but also hold an evidentiary hearing as to the parent's inability or unavailability to parent, and not just to dad. Think about, why can't mom parent? Even if it's not abuse, abandonment, or neglect per se, but let's say mom could no longer protect the child from the gangs, could no longer protect the child from dad. Why is each parent unable or unwilling to parent in this circumstance? As I mentioned, there are temporary guardianships. There's a higher burden to show if you want a temporary guardianship, and then an even higher burden if you want to show an emergency guardianship. But I've given you the Colorado revised statutes here, and you can take a look for that. If you have to pursue a temporary or emergency guardianship, please keep in mind, because of that policy manual that was just issued in October that Ashley mentioned, you have to then follow through with the permanent guardianship. Okay, it's not enough. You may be able to file the petition for special immigrant juvenile status with your temporary guardianship, but by the time that case goes to an interview, or by the time you file the petition for lawful permanent residency, you want to have the permanent order, okay? Okay, couple more procedural things. Guardianships, you can find all the forms for guardianships on our Colorado Judicial website. You can also find an instruction guide. Okay, so if you've never done a guardianship before, but you really want to do it and you think that you can wrap your head around it, because we are all smart attorneys who absolutely can do this, look at the how-to guide, okay, on the Colorado Judicial Forms website. They will walk you through it. These forms are filed, e-filed through a SIJS, unfortunate name that Colorado has, for their e-filing system. And if you don't have that capacity, then talk with Ashley. RMIAN can help you do that. Or you can talk to me and I can convince my office manager to do it for you. A potential guardian must submit to a criminal background check and submit a credit check from one of the three credit bureaus, Experian, Equifax, and I can't remember the other one. So that is one requirement of guardianships. Again, we talked about this, parents must consent. I want to talk about building a record, just like Ashley said at the beginning. You need to build a record in this state court proceeding because immigration, as they want to do, will come back and say, we want to know what evidence did the court take into consideration? How is this valid under state court law? They are so skeptical of these state court proceedings. So please, even you, there are amazing judges in Colorado, and some of them will look at your motion and they'll look at your order and they'll just say, okay, and I'm going to sign this. And you do have to step back and say, Your Honor, I need to build a record. I need to take some testimony because immigration will come back and look at this. As I said earlier, guardianships are typically granted with one hearing. If you want to submit any additional documents, you can do that. Like, for example, if you have a death certificate of a parent, I would submit that. If you're, like in the hypo, Julia potentially has scars from the abuse from her dad, if you can submit pictures or a doctor's evaluation as to scars, anything that you can be creative and think about to support that abuse, abandonment, or neglect finding. Okay, I'm gonna talk really quickly about service because this is the question that I get the most from volunteer attorneys or immigration attorneys who are entering into this world of state court guardianships. There are two international conventions that are a total pain in the ass. One is the Hague Service Convention, which has a much longer name that I'm not going to repeat. And then there's an Inter-American Convention on Letters Rogatory and Additional Protocol. I have 15 minutes? Okay, thank you. So just take a look at these conventions, please. Each country has different exemptions or prohibitions of each of these each thing. So just take a look at it. Like El Salvador will say, we won't do X, Y, and Z, but Guatemala will allow that. Just know that these exist. And then I'm going to say, if you have the consent of the opposing party, meaning the parents in a guardianship typically, these conventions don't apply, okay? However, you may have a problem enforcing a guardianship in another country if that country doesn't allow waiver and acceptance of service. So wrap your head around that. The Hague and these interconvention and the Inter-American Convention do apply if you have a known address for the person and that person is not cooperating with you. Okay, so you know where dad is, you have his address, he's not going to sign anything for his daughter. You are going to have to follow these procedures, okay? And it involves a letter to our Justice Department, and they write to Guatemala's Justice Department, and the father gets served. If you have the situation, please call me or email me, and I will help you. If you don't know the opposing party, and this is a situation where, you know, I've had a client where she was conceived from a rape. There's no dad on the birth certificate. There's no, mom didn't know who dad was, and then mom died. Okay, so you may have an unknown opposing party. And I want you to know that there is a process in Colorado for service by publication, okay? And it's not publication in Guatemala, it's publication in the county where you filed the petition. So just come back to this. Like Ashley said, we have too much information on our slides. Okay. Very quickly, common obstacles. You have an undocumented petitioner and that person has to go to court. Please screen the petitioner if he or she is undocumented and make sure they do not have criminal history and do not have a final order of removal, because I'm sure, as you all have seen in the newspapers, ICE is making appearances at state courts. They used to do this. They stopped doing it, and now it seems to be happening again. So please take a minute to review the immigration and criminal history of the petitioner before you send them into court. Second, undocumented petitioners sometimes have a hard time with credit checks. You can do a motion to waive the credit check requirement. For example, most undocumented people are not going to have a social security number, right? So how are you going to do that credit check? What I typically do is I try and do the credit check online. I get the rejection. I try and do another agency. I get the rejection, and then I submit that with my motion to the court and say, we can't get a credit check. The child does not have significant assets, and this individual is working and can support the child. Educating your judge. I want to impress upon you that your role is translator. Every finding that we are asking in the SIJS piece is also based in Colorado law. Okay? Every federal finding that you need for special immigrant juvenile status has a basis in state court law. And that is what you need to convince your judge, right? Even though we're asking you to use this fancy language, it really just means the same thing as this language that's in our Colorado revised statutes. In the context of guardianship, unwilling or unable to parent, please make an analogy. How is that similar to abuse, abandonment, or neglect? Make that analogy in the state court hearing, because immigration for sure is going to want to know about that. Some judges, who are nice judges, will extend guardianships past 18 years. However, there's really no statutory authority to do that, and immigration will come back and say, show us the site. How is this 21-year-old in a guardianship of a minor situation? There is a high standard for adult guardianships, even though like an 18 to 21-year-old is still eligible for SIJS under federal law. It's going to be hard to get that child into state court proceedings unless they're incapacitated or have severe developmental issues. One thing I didn't put on here, dad not on the birth certificate. According to our new October 2016 policy manual, if dad is not on the birth certificate, the state court has to make, as a part of the SIJS finding, we acknowledge that this person is dad based on mom's testimony. We served him, and we are finding that he is the father. Okay, this is something that has long been coming with cases that dad isn't on the birth certificate. Okay, here is another thing that we can't read. Okay, this is where I want you to start when you are about to go into your guardianship hearing, so that you can be translator to your judges, right? So I've gone through, Ashley put 1, 2, 3, 4 on her past slides. I've gone through and done 1, 2, 3, 4 to show you where in our Colorado statutes gives them the authority, for example, to place a child in a guardianship with this individual, okay? Then this unable and unwilling to parent, where is that found? And how can we make the analogy that this is similar to abuse, abandonment, neglect? Best interests in Colorado control everything, okay? So the court has wide authority to make best interest findings. You could swallow the whole SIJS order in a best interest determination if you wanted to. And then again, we have the issue of jurisdiction, okay? One thing I want to add, which Ashley touched on and I also touched on at the beginning, is you want to show how going into state court is necessary to relieve the child from past abuse, abandonment, or neglect, right? I mean, that's what immigration is after with their consent function. They want to know, how does this protect the child? So take a minute to think about that in your brief, in the testimony questions you're going to ask of the guardian. Here's some other good language from the probate code. I also mentioned a policy here that has since been superseded by the new policy from October, but it does specifically mention guardianships as the forum through which you can get the SIJS order, and this might be helpful as a tool to educate the judge who you are in front of. Okay, I covered a lot of what I wanted to with the guardianship and also in the allocation of parental responsibilities, so we're going to go through this really fast. Again, APR is Colorado's fancy word for custody. Just a couple things to think about. Most of the time, parenting classes will be required. Even if you're not the parent, you have to go to a parenting after divorce class, which doesn't make a lot of sense, but just do it. Child support is an issue in the context of allocation of parental responsibilities. So parties will be required to disclose financial information, although I have been successful in waiving that requirement if both parties agree, right? And sometimes when I say parties, I've had a couple cases where I have mom putting forth the petition, dad is the abuser, right? Dad is in El Salvador, and then mom wants to give partial parenting time to Aunt Ashley, right? And so Aunt Ashley and Mom Katie could go in with a partial stipulation to say this is how it's going to look like in this context. And we don't want to exchange financial information, but maybe mom does want to put a child support order as to dad, which I always recommend. Just ask for it because it extends the jurisdiction and it's the child's right to have child support. So mom and I, or Aunt Ashley and I, are not going to have to exchange financial information. We're going to ask the judge to waive that, but we will require dad to do it. And if dad's not cooperating, I mean, the child support order is sort of moot, but it's nice for the child to have that order. Okay, who can file an APR? We talked about this a little bit. A parent, a person other than the parent, but only if the child is not in the physical custody of one of the child's parents. So what I do not recommend, and Remain would never do this to you either, is do not create a situation in order to fit this law, okay? I don't want Brian Martinez going to live with Aunt Ashley when my son Brian Martinez lives with me, okay, for the purposes of getting this order. It will not fly. I always tell my clients, just tell me the truth and we're going to see how we can then fit around the truth. I do not want to create a situation to make SIJS possible, if that makes sense. I think it's fraudulent. I think we have ethical problems, and immigration will absolutely find out, because they always do. A person other than a parent who has physical care of the child for more than 182 days if that child is no longer with the parent. So I mean with that person. So we don't see this situation a lot. Again, procedurally, the forms are on the Colorado Judicial website, e-filed through ISIS. The petitioner does have to disclose criminal history, restraining order history, civil judgment history, other court-appointed responsibilities, but there's no CBI requirement. There's no credit check requirement. Again, build a record. We talked about the possibility of a partial or a full stipulation, and again, typically requires more than one hearing. Okay. I'm going to get it done in 5 minutes. All right. Again, serving the opposing party. This is similar to the guardianship context, but what I do want to point out to you is that if you have an unknown opposing party or unknown whereabouts, that the process of request of publishing service by publication is different. Okay. In guardianship, you can do an affidavit of due diligence, meaning, you know, I looked for dad on Facebook, I looked for him on Snapchat, I talked to his brother's friend, I talked to the mechanic in Guatemala that fixes his car, no one knows where he is. You can submit that and then publish. With APR, you have to request from the judge the ability to publish. Okay, so you have to do a motion for permission to publish, and that's just an extra step. Okay, APR and SIJS. Again, I've gone through the Colorado Revised Statute to talk about each of the different, oh my God, I need reading glasses. What I do want to mention though, with SIJS finding number 2, right, that's the abuse, abandonment, neglect finding, which I didn't mention at the beginning. The Immigration and Nationality Act does not define abuse, abandonment, neglect. They rely on the state court definitions, which is why here I've shown you where abandonment is defined in our Colorado Revised Statutes under Title 14, which is the allocation of parental responsibilities. Title 14 also references other statutes, namely the Children's Code, which is Title 19, and the Criminal Code, which is Title 18. So your job is to look at the motion that Ashley has and find how can we make this analogy that this judge can find abuse and neglect, okay, or abandonment. The jurisdictional issue, again, with APR is a little bit different. Title 14 does define a child as under 18, Okay. However, they do allow you to extend jurisdiction to 19 in certain circumstances. So take a look at this 1410-115 subsection 13 if you're hoping to extend the jurisdiction. Okay, and why this is important. Because a child is only protected under the age out provisions of the policy manual and the Immigration and Nationality Act if they age out. Okay, so we want jurisdiction to last as long as possible, because for example, if a child is in a guardianship at 17 and a half and then, you know, at 2 weeks before he turns 18, he's like, peace out, I'm not living with you anymore, that child's not protected. Okay, so I always argue for as much protection as possible. And so this is the statute in the CRS that allows for jurisdiction until 19. And we also have other arguments of jurisdiction lasting until 21, but some judges buy that and some judges don't. So if you have a kid who is 18 to 21, really, let's talk about it. Ashley and I can talk about it and see what we can do for that child. Okay. This is other good language. Here's the language for temporary emergency jurisdiction. Okay, so if the child has been here less than 6 months, you can't establish that Colorado is the child's home state. Look and see if you can fit the temporary emergency jurisdiction provision. Again, it's you have to demonstrate that the child has been abandoned, or the emergency jurisdiction is necessary to protect the child because of mistreatment or abuse. So if you have a child who's been abused, abandoned, or neglected, I think you could argue for this temporary emergency jurisdiction. Okay, one last thing. I probably have 1 minute. I do just want to throw out there adoption, okay? Because in Colorado, our statutes allow for the adoption of a child between the ages of 18 and 21 with leave of the court. So it is possible to do an adoption of a child who is 18 to 21. And in some cases, that might be the only recourse that's left, because you can't get into guardianship proceeding with a 19-year-old. You can't initiate an APR with a 19-year-old. They have to be under 18 when the proceedings begin. We talked about joint guardianships, and then I just want to point out, if you look on the Colorado Judicial website, there is a special power of attorney. It's Form JDF 751, because I know people are asking, what can I do if I get picked up? And this provides a bare bones power of attorney to people who might need something. And that's separate and apart from special immigrant juvenile status, but that's all that immigration attorneys are talking about right now on our listserv. So if you have people who are undocumented, maybe even apart from your remain cases, and they're worried about the kids, print this out and encourage them to talk to a family law attorney about how to fill it out and how to protect their kids in the event that they're detained. Okay, back to Ashley, Aunt Ashley.